Are you considering hiring an attorney to represent you and want to better understand the engagement you are entering into? By the end of this video, you will learn what an engagement agreement is, why you need to have an agreement, and how to read the key elements of your engagement agreement. Hi, I'm Darcy Buxton, a paralegal at Minc Law, the nation's leading law firm for online defamation and content removal. Hiring the right attorney for your legal matter can be a challenging process. One aspect that can be intimidating is understanding the terms and conditions of an attorney engagement agreement. In this video, I am going to discuss what an engagement agreement is, why it's important to have one, what an agreement should include, and what to do if you have questions on the terms of the agreement. An engagement letter, commonly referred to as an engagement agreement, is a type of contract that outlines the scope of service, cost, terms of service, or goods to be rendered. The letter should also define the responsibilities of both parties during the time span of the agreement and discuss which parties have the right to cancel representation. To put it simply, an engagement agreement defines the legal relationship between the firm and the client. Engagement agreements are important for a variety of reasons, but mainly for protection of all the parties involved. The agreement ensures transparency and demonstrates professionalism from the beginning of the attorney-client relationship. You know exactly what you are paying for, and the firm knows exactly what is expected of them. Having an agreement in place will help prevent misunderstanding or confusion during the course of the representation. Should an issue arise during the course of the representation, both parties have the protection of the agreement to fall back on. An engagement agreement sets the terms of the agreement between two parties. It will designate how the working relationship starts and ends. Most engagement agreements cover the following 6 components: the hourly rates of all attorneys involved in the matter, possible fees that may occur, the amount of time allotted to the client to dispute fees or expenses after they are billed, and any interest amounts due upon late payments or bounced checks, the starting retainer fee that is due at the time of signing the engagement agreement, the firm's ability to cancel the contract upon failure to pay legal fees, and the client's right to terminate the representation if they are not satisfied, and dispute resolution between the parties. While engagement agreements vary between law firms, they generally contain the same basic elements. We recommend that you look for the following core elements and ensure they meet your expectations before signing the legal engagement letter. Who is the client? Does the agreement have your legal name listed and is it spelled correctly? What is the scope of work? Are there any exclusions to the work that is being described? What are the fees and costs associated with the contracted services? What are the responsibilities of both parties? Are there grounds for withdrawal or other consequences for breach of the agreement? Is there a time limitation for the contract? When does the agreement take effect? And does the agreement stipulate any guarantee or state that there is no guarantee on the results? The provider of the service is who will draft the agreement, since they know what service is they are providing and what the expected cost will be. You as the signer should fully read and make sure you understand the entire letter to make sure that your interests are protected as well. If you have any questions, now is the time to ask them. One thing to keep in mind is that a written contract is not binding on either party until it is signed. If you have questions or concerns, you should address them before you sign the agreement. If you disagree with certain elements in the document, you do not need to sign it right away. You have the option to discuss your concern with the attorney. Contract negotiation is the process of coming to an agreement on a set of legally binding terms. When two parties negotiate, they both seek favorable terms. However, negotiating too much can send the wrong message to the attorney and could potentially taint the relationship. Attorney-client relationship is based on trust, and for the most part, you should trust your attorney. In situations where the terms of the agreement must change during the course of your representation, it is best to obtain a new agreement or a supplemental letter to reflect those changes. If work on a new matter is needed, the attorney should send a new engagement agreement with new expectations for the work to the client. Lastly, We recommend that the attorney and the client review the terms of the agreement at least once annually. This review can determine if any changes are needed. I hope I was able to answer some of the questions you may have about engagement agreements and why they are important to have in place. Don't hesitate to reach out to me or any of the other paralegals by calling us at 216-373-7706 or filling out one of our online contact forms. This is Darcy with Minc Law, and I want to thank you for watching this video.